Good morning, everyone. My name is John Cornwell, and I'm the Director of Marketing and Business Development here at Plunkett Cooney. It's my pleasure to help out with today's call. As I indicated, I'll be kind of the admin person in the background, so you may hear me pop in from time to time. I'm certainly glad we're having this session today. It's safe to say that in the new year, we've been dealing with a lot of challenges, and this webinar is all about tackling those challenges. And so we've got a jam-packed agenda here for you today. I'm joined here with a group of our labor and employment group attorneys. Courtney Nichols is one of our co-leaders of our labor and employment practice group, and I'm going to throw it over to her to take it from here. So Courtney, take it away.
Great. Thank you, John. Thank you all for joining us. We know how busy all your schedules are, and we really appreciate you taking a couple of hours to spend some time with us today to catch up on the year that we've had and to talk about where we go from here. So we want to remind everybody that we are recording this program. So for the people that are concerned about jumping into a breakout and maybe missing a conversation in the secondary breakout, it's all going to be recorded. Our question and answers will be recorded as well. So if you need to access this recording at a later date, we can provide that to you. We are also offering continuing education for the program today. So make sure if you have any questions about that, to follow up with us after the program so that we can get you all set with your applicable continuing education credit. Now I want to walk you through our seminar today. So we're starting with a plenary or a general session where we're going to walk you through the 2020 year that we all want to forget sooner than later, and now where we're at today in February of 2021 and where we're going to be moving forward. We want to identify the primary issues that we've seen employers face and how we've counseled them through those issues and what we think are the best practices to avoid similar issues moving forward. Now, there's a lot to cover in this general session, as I'm sure you all unfortunately know. So we might go a little bit past an hour, but we want to assure everybody that if you have questions, please put them in the chat function, and we will try to get through the questions at the end of the program. Also, we will have an opportunity after the breakouts to come back and to talk about what happened in the breakouts just briefly, and then to address any questions that you might have at that time. During the breakout sessions, one which will focus on speech and one which will focus on wage and hour issues, it's, again, supposed to be very interactive, so feel free to include your questions in the chat, or at the end, just jump right in, and we're on Zoom, so we can ask questions, we can unmute you at the end of the program. But we would ask that everybody be cognizant of the fact that you should be auto-muted, but if for whatever reason the mute comes off, make sure that you try to catch that and get it back on so that our recording is clean and that we don't have that background noise. Now, generally, we like to do the seminar in person, and I am really disappointed that we can't be seeing you all face-to-face in person this year at the Marriott or in Detroit with prizes and games and funny videos. There's a number of videos I wanted to put in this presentation, but I didn't want my computer or your computer to explode after a year of working from home. So what we want to do is for individuals that complete the survey, which is really important to us, figure out where we can improve, what you liked about our program, and what we might be able to help you with in the future. If you complete the survey, we're going to do a random drawing, and 3 lucky survey completers will receive a gift card for DoorDash to get yourself lunch today or another day this week. So please, please, please complete those surveys, and we'll try to get you all lunch at some point in the near future, and those gift cards will be emailed from our marketing department. So that's the program for today. With that, I want to introduce the panelists for our general session. If you've been to our programs in the past, you're probably familiar with us. I am the first one there on your left, Courtney Nichols. I'm one of the co-leaders of our labor and employment practice group. This is what I do. I'm almost exclusively practice in the area of employment law here in Bloomfield Hills, Michigan. In the center of the screen, you have Laura Dinan, who, if you have any work in the northern Michigan area, you will know Laura. She covers our ground up north. She's based in Petoskey, but can handle anything in that area of the state and also in the UP. And then on the right, you have Claudia Orr, who is based out of our Detroit, Michigan office, and she counsels a number of our clients. She's a prolific lecturer and panelist, and I really could not be happier than to have these 2 wonderful people with me today to walk you through the year we've had. So let's get started. A difference the year makes. So this might have been what our work life looked like in February of 2020. And now I am spending my days rewatching the hilarious video. If you have not seen it, I urge you all to see it, of an attorney who did not realize he had a Zoom filter on and was a cat in front of a judge. And it concludes with him telling the judge, no, judge, I'm not a cat. I'm not a cat. This is me. I'm ready to go. It's just so classic. But this is where we're at. And I'm sure we all have some funny Zoom stories. I know I've had some Zoom mishaps myself, despite the fact that I use this platform multiple times every single week, and I have since March of 2020. But here we are, a totally different world. Some of the same problems, of course, but things we're doing now that we never in a million years thought we would be doing back in February of 2020. So I just want to snapshot some of the things that we've worked through over the past wild 12 months. So I think this slide really puts in perspective some of the changes that we've all experienced. And this is literally the tip of the iceberg. I could not have possibly identified every executive order, every rule change, every piece of legislation that was considered. There are a number of things that might affect employers that we just can't squeeze into this time slot. But walking through, from March until December, we go from a state of emergency being declared to a new law becoming effective that provides workplace protections to individuals who might have been exposed to COVID or have COVID symptoms. So that is a wild 9-month time span. A few of these things I'm sure we are more familiar with than others. The stay home, stay safe order, the really infamous one, which was shutting us down, in other words. The Families First Coronavirus Response Act becoming effective in April really had a significant impact on smaller to mid-sized employers. Then you get Michigan actually coming in and invalidating executive orders that were issued after the first state of emergency was expired. You get Miosha issuing emergency rules to be in effect for 6 months. We're still under those Miosha rules. And then, as I mentioned, you get additional laws and orders from the Michigan Department of Health and Human Services. So where are we at today? Okay. The first thing is we have Miosha emergency rules, which are still in effect. So the Miosha emergency rules, I'm going to get into the weeds on that, but just so everybody knows, nothing has changed with regard to the emergency rules that were issued in October. Then we get the Families First Coronavirus Response Act, or the FFCRA, because us employment attorneys cannot get enough of acronyms. That law sunset, the applicable leave provisions had a sunset provision, meaning that they stopped becoming mandatory on December 31st of 2020. However, the government has said that employers can still provide the leave benefits and get the tax benefits through the first quarter of 2021. It's not mandatory, it's permissible. That's something we'll get into. We have executive orders. The vast majority have been totally invalidated. So if you're looking at executive orders regarding workplace protections, those are no longer effective. And then we get Michigan Department of Health and Human Services. Those orders are still in effect. We have a state law that's still in effect. We have OSHA rules that are applicable, Miosha in particular here in Michigan. We have ADA FMLA that might be applicable dealing with COVID issues. And we have Pmla, which might be applicable dealing with COVID issues. So we got a lot of ground to cover in the next hour. And I apologize if we're all talking fast. I can assure you it's not just a stream of coffee and espresso. It's really our intent to arm you with as much information as we possibly can in a short time frame. So I wanted to address a few of the primary issues that employers face today from my perspective. Okay, my perspective is since March, I've been dealing with client calls and webinars and presentations and talking to other attorneys and other people in the industry about where we're actually seeing issues crop up as opposed to just potential speculative problems. So the one thing that I've seen consistently is that there's confusion about the Miosha emergency rules as compared to the Michigan Department of Health and Human Services orders. A lot of people don't really realize that Miosha even has these emergency rules, or they assume that MDHHS is trumping them in some way. That's not accurate. So really making sure that everybody gets what those emergency rules mean and how they apply to your business is of the utmost importance. Another question is remote work. This is one that comes up every single week with multiple clients, and everybody that I've talked to, there's somebody typically in the company, and maybe it's not the majority, but there's usually a few people that are chomping at the bit to get people back and not remote working. And so this is a common theme. When can we bring our people back? Do we still have to do remote? How do we do this? Then you get actual claims and litigation. Now, I will tell you that there was like a string of time in the summer where I received multiple lawsuits alleging retaliation under the Families First Coronavirus Response Act and public policy discharge. And I think that we're going to see more of the public policy discharge claims moving forward, which is why we want to talk to you about that. And then, of course, just Michigan law. What does that new PA 339 of 2020, what does that even mean? How do we apply it? And as always, the ADA is just a looming issue. It just constantly follows us around our workday. So Claudia Orr is going to spend a lot of time talking to you about ADA issues. But we just want to highlight these as really being the 5 biggest areas of problems that employers face today. So I want to talk to you before I hand it off to Laura in a little bit more detail about the Miosha emergency rules. So everybody should be generally familiar with these. I don't want to give you information you already have, but just to set the stage. On October 14th of 2020, Miosha issues emergency rules that are in effect through April of 2020, right? Through April 14th is a specific day because there's 6-month emergency rules. Now, to bring you up to speed, we had the applicable workplace protections that were articulated in executive orders. So first there was the shutdown order. And then, as I'm sure many of you will remember, there was the order providing specific workplace protections to employees that had COVID-like symptoms. So that was the order 2020-37, and then it sort of changed over time, that required you to let people off of work for particular periods of time if they had COVID symptoms. And then there was a workplace safeguards order that had specific things that you had to do from a both prevention and a response standpoint in your workplace. So that was the order that said you have to have the COVID-19 preparedness and response plan. You have got to take these measures. You know, you got to have the markings on your floor 6 feet apart. You have to wear masks. You have to close down conference rooms. All those workplace safeguards. So they start as 2020-37 or as 2021-24, and then those numbers increased over time, which I know many of you thought that was really neat, trying to keep up with those numbers as they were constantly evolving. So we were always trying to send out emails or do webinars and say, okay, this is what the order is and this is how it applies. But the takeaway was that there were a number of very similar safeguards in all of these orders. So when the Michigan Supreme Court said that Governor Whitmer's executive orders after the state of emergency had first expired were invalid because she no longer had the authority to be issuing those orders without going through the legislative process, then what happened was 2 of the departments that work closely with the governor's office, Miosha and the Michigan Department of Health and Human Services, basically started creating their own orders under their own emergency powers, not under the power of the governor's office. And those orders, when put together, mirror a lot, if not all, of the safeguard protections from the executive orders. So again, you get the Supreme Court saying the executive orders are invalidated, but very shortly after you get Miosha saying, okay, well, we'll take care of that ourselves. All right, so Miosha issues these emergency rules. They're available online. If you don't have them, you should have them, print them out, make sure you use them. But the most important thing, in my opinion, that Miosha did was they answered FAQs. So the FAQs really give us some more insight into how they're dealing with these things and what the primary issues are going to be. Now, in terms of the most common Miosha questions, there are a few that tend to come up far more often than others, okay? The COVID preparedness and response plan. Now, this is something that, again, evolved because we saw it first being referenced in an executive order, and then OSHA had a template, and then Miosha had a template, and you can get about 40 different templates online if you have that time on your hands. So what one governs? Well, the Miosha emergency rules provide that you have to do particular things in your COVID-19 preparedness and response plan. You have to have an exposure analysis. You have to identify, are we putting our employees in a high, medium, low risk job? And you have to go through that actual process step by step and have it documented for the different classifications. So for example, here at Plunkett Cooney, everybody's going to be low risk because we have really no need outside of maybe the male people to be in the office, much less interacting with other people, short of individual circumstances that might dictate it. So for other businesses, it's going to be high risk, right? Healthcare workers are often in a high risk category, but you need to look at your business and make sure that you have your people in the right categories. The other thing about the COVID-19 preparedness and response plan that's a little bit different with the Miosha emergency rules is that you also have to document why you have people in the office if that's the case. So that's what we would call the job feasibility issue here, which is critical to walk through and just make sure that you have that support if you get a knock on your door. Now, what's the risk if I don't have this plan at all? I will tell you, I wouldn't advise that you should just throw caution to the wind and think, well, we're 6 weeks out, so we're going to be good to go. If you get a Miosha complaint, and if Miosha comes to investigate, they're going to ask you for your COVID plan. Okay, I've had multiple of these pop up, and the first thing they ask for is your COVID plan. So if you don't have it, that's going to be a standalone violation, but it's going to be added on to the others. Now, I have not seen, and if anybody has this experience, I've not seen Miosha spend time just knocking doors of random businesses with no complaints, no concerns, no cars in the parking lot, just to cite them for not having a COVID preparedness and response plan. And I've not seen any citation published for just a failure or an inaccuracy with the COVID-19 preparedness and response plan. And we can see what Miosha is issuing citations for, and they do publish what their recent slew of citations are for. So the big one, and I wanted to save it for last for our Miosha discussion, is the remote work issue. Okay, and I know that many of you have grappled with this. I can't think of somebody that's looked at this and just thought, well, this is super easy to deal with, let's move forward. The rule that's implicated when we talk about remote work arrangements is 5.8, okay? And that rule specifically says that the employer shall create a policy prohibiting in-person work for employees to the extent that their work activities can be feasibly completed remotely, okay? So what does that mean? We unfortunately don't have a clear black and white answer other than Miosha saying, if we come to your business and there are people there, we're going to want to see what analysis you did to determine that they cannot do their job remotely. Now, for some businesses, this is super easy, right? If you have a manufacturing plant, if you're an automotive supplier, if you have to have people, in a plant office environment to conduct their job duties, quality sorting, things like that. Super easy, not complicated. The more tricky analyses lie with the more quote unquote white collar office environment, the more sales heavy office environments. People like us, lawyers, right, where we're generally capable of doing our jobs remotely, but for some people it's not feasible. So for us here at Plunkett Cooney, when we have people that cannot work remotely, we have it identified in writing and explained, and that way if we ever get a knock at our door asking, why are you all sitting in your office instead of working remotely, we have something to show Miosha, and we expect that will be sufficient. So that's what we recommend, is that we understand that some people cannot feasibly work remotely. It's not a bright line rule, but if you're going to have people back, make sure you have it documented so that you can justify that reasoning if you are subject to an investigation. But I do want to know, I don't want to give anybody a false sense of security, but where we've seen people cited for not complying with the remote work environment is where they're cited for other things. Okay, so either not having a plan at all or not wearing masks, which is a big one, and that will immediately get Miosha on your case. When they can find multiple problems, that's when they're far more likely to flex their enforcement and investigative muscles. So note that. Also, back in November and October, when this rule was hot off the presses, Sean Egan, who was doing webinars from the Miosha Enforcement Division, had mentioned that they were really scrutinizing this at that time for the next few weeks, because as I'm sure you all remember, the cases were off the chart. So now we've seen a huge decrease. We've seen less strict enforcement efforts. We expect that this rule will go away after April, or at least be significantly lessened. But for now, if you have people there, make sure you explain why. Okay, so that's my Miosha pitch. Now I am going to pass it off to Laura Dinan to talk about an ever fun topic, which is retaliation claims.
Thanks, Courtney. This is an area that we have been seeing cases, and we're going to continue. Employees in all sorts of businesses are alleging they've been retaliated against, and the primary reasons are because they didn't come to work when they had COVID symptoms or had close contact with someone who did, or they complained about workplace safety policies, or they complied with the provision of an executive order or Michigan law. I've had tons of phone calls, and I know Courtney and Claudia have also, from employers who have employees who just don't want to come to work. And sometimes it's for protected reasons, sometimes it's not, but guaranteed they all feel like they're being retaliated against when they don't want to come to work. And the laws and health department orders that have been passed make it clear that employers cannot retaliate against employees. And it's not to say that all the actions you take or are considering taking are retaliation, but as usual, the employees feel that way. Both federal and state law contain anti-retaliation provisions. Under the FFCRA, the general concept is that an employee that's asked for leave or did take leave that's considered by under the Emergency Paid Sick Leave Act or the Emergency Family and Medical Leave Act, and then the employee's subsequently demoted, laid off, terminated for whatever reason, might have a basis to bring a retaliation claim, and that is prohibited, specifically prohibited under the FFCRA. It allows employees to pursue a private action against their employers to seek remedies under the FFCRA, and the remedies under the FFCRA are the same as those that are allowed under the Fair Labor Standards Act. So they can get lost wages, liquidated damages, and attorney fees if they're successful in alleging retaliatory discipline or discharge under the FFCRA. And another key thing for you to know is that under the FFCRA, individual managers can be sued and be liable, not just the company. Under the FFCRA, there is no requirement that the employees have to go through an administrative agency or exhaust administrative remedies before filing a federal lawsuit, which is somewhat different. Usually, as you know, if employees want to bring a federal claim, they have to go to the EEOC first and go through that process and get a right to sue letter. They don't have to do that if they want to bring a claim for retaliation under the FFCRA. These claims often turn on the close temporal proximity given the nature of the claim. So if they make a complaint, if they don't come to work and shortly thereafter discipline or termination occurs, there's going to be, it's going to look very bad for the employer. It's going to look like retaliation and support a retaliation claim. So what can employers do? Training and documentation are really critical to limiting exposure in this area. You need to have an in-house person, whether it's HR, a particular manager, the company owner, someone who is intimately familiar with the provisions of the FFCRA, so they know it inside and out. And then you need to train all of your managers on the FFCRA and the rights your employees have and what the company and the managers can and cannot do with expectation over employees who ask for basically accommodations related to COVID issues, whether it's exposure, workplace safety, things like that. And then if someone does come to you with a request, with a complaint, asking for accommodation, you need to have documentation about everything that they've asked for, that's happened, that you've done. Document your decision-making process and the reason that you made the decisions that you made. And anytime that you're going to make a discipline or a termination decision, something that's going to affect the employee adversely, make sure that you think through every step of the way, taking into consideration the FFCRA, because a red flag should go up that this could potentially lead to liability. the other area that affects employers in Michigan, there's a new state law that was passed in October, and then amendments were passed in December. And that is Public Act, the October law is MCL 419.401, and the act in December is Public Act 339 of 2020. And it's an act to prohibit an employer from taking certain actions against an employee who does not come to work under certain circumstances related to COVID-19. And they're all set forth in the act. It's pretty easy to research online or check with your attorney. But basically, it prohibits employees from coming to work under certain circumstances related to COVID-19. You know, if they have been exposed to someone who has it, if they've been exposed to someone who is exhibiting symptoms, if they themselves have it or are exhibiting symptoms. And this act prohibits them from coming to work if they experience those situations. It also prohibits discrimination and retaliation for engaging in those activities. And it provides remedies to the employees if the employer does take action and it appears to be retaliatory. So again, this is with respect to Michigan law, but it's something that you really have to be aware of, and the requirements of allowing employees to be out of the workplace and actually requiring employees to be out of the workplace are very explicit. And so everybody should be familiar with those and aware that employees have these rights. And some of the explicit provisions are that if an employee tests positive for COVID-19, they must not report to work until they're advised by their healthcare provider or a public health professional that they've completed their isolation period, or all four of the following conditions are met. If the employee has a fever, 24 hours have to have passed since the fever has stopped without use of fever-reducing medication. They've waited out the isolation period according to the CDC guidelines. The employee's principal symptoms of COVID-19 have improved. And if the employee was advised by a healthcare provider or a public health professional to remain isolated, the employee is no longer subject to that order. And then if somebody displays the principal symptoms of COVID-19 but hasn't yet been tested positive, the employee shall not report to work until one of the following conditions is met. They either have to have a negative diagnostic test result, or all of the following. Isolation period has passed since the principal symptoms of COVID-19 started. The principal symptoms of COVID-19 have improved. And if they had a fever, 24 hours have passed since the fever subsides without the use of fever-reducing medication. So, what is the applicable quarantine period? We get a lot of questions regarding that. It's a moving target. It is something that you can easily find on the CDC website, and they update it fairly frequently. Currently, the CDC still recommends a 14-day quarantine period, but they, hold on, I just looked that up this morning. They recommend 14 days, but it can be as little as 7 and up to 10 days. So if you meet the requirements on the CDC site for the 7 or 10 day quarantine period, they still want you to watch your symptom or watch for symptoms 14 days, but under certain circumstances, you can return people to work before that. And another frequent question is, people want to know, how many symptoms does an employee need to be experiencing to have protection under this law? And there are two categories of symptoms. If an employee has a fever, shortness of breath, or uncontrolled cough, any one of those things is enough to meet the requirements of the law and bring them under the protection of Public Act 339. If they have abdominal pain, diarrhea, loss of taste or smell, muscle aches, severe headaches, sore throat, or vomiting, if they would have to have 2 of those second-tier symptoms to be brought under the protection of the law. A diagnostic test is a test where they test for actual active COVID, not to see if you have antibodies. The exceptions to the close contact rule are that if a person is experiencing symptoms but has not tested positive and they fall into a category of public safety, healthcare workers, corrections, childcare workers, first responders, or utility workers, then they can return to work as long as they don't have symptoms and haven't tested positive. I think I misspoke. So they have no symptoms, they haven't tested positive, but they've been in close contact. But if they fall into one of those exceptions based on job duties, they can return to work without quarantining as long as they watch for symptoms. And then finally, we get this a lot. What if an employee drags it out, waits several days to get tested, continues to complain about symptoms, has multiple cases of exposure? For the most part, employers can't do much about that. They're going to have to follow the provisions of the law. They're going to have to give the employee the benefit of the doubt. However, under Public Act 339, if an employer asks an employee to get a test and they don't get it within 3 days, they lose protection under Public Act 339. So there is that out for employers. But for the most part, the employee gets the benefit of the doubt these days. So Public Act 339, another requirement is that with certain exceptions, employees who had close contact with an individual who tests positive for COVID-19 shall not report to work until one of the following conditions is met. Either the quarantine period has passed since the employee last had close contact with the individual. This occurs a lot. I get a lot of questions when somebody has a family member that they're either caring for or living with, and that person comes down with COVID. The quarantine period does not start until their last contact with the individual. So they might have to wait out the entire isolation period with the person they live with, and then the quarantine period starts. So it can be a pretty good chunk of time that they have to quarantine, because if they're in direct contact with them or close contact, then they might have to wait out the isolation period until the person is better and then start their quarantine period. So either they wait that entire period out, or the employee is advised by their healthcare provider or public health professional that they've completed their period of quarantine, which could be that the healthcare provider looks at the facts and says you don't have to quarantine anymore, even though you haven't waited out the CDC guidelines. But those are the only way individuals who've had close contact can come back to work, other than the exceptions for certain jobs. And
Laura, one quick thing I wanted to join before we changed it over to Claudia was, I know that this has come up in the past week or so for me, and it's relatively new, but the close contact rules or the quarantine rules for vaccinated people. So this isn't in our PowerPoint because this is relatively new, but I did just want to note before we moved on to the next subject that on February 11th, the CDC updated guidance regarding if somebody's been vaccinated, how that affects their quarantine period. So I just want everybody to be aware of that. So if you get an issue under PA 339 or 339 of 2020, and you're trying to figure out, okay, the quarantine period relies on the CDC guidance. If you have a vaccinated person, that's going to be an additional step in the analysis to look at the specific guidance regarding those people to determine that applicable quarantine period.
Thanks, that's a good point. So I think now we're turning this over to Claudia.
Hi. So we need to remember that there's some basic state laws and federal laws that can't get lost in the mix, because we're all excited about the new family first laws and things like that. But there's the good old standbys that you have to work through the analysis on as well. So keep in mind, you know, the American with Disabilities Act, which applies to employers with 15 or more employees. There's not a whole lot you have to do under the state law. There may be some obligations, but generally it's the American with Disabilities Act that you have to keep in mind. And of course, you know, it requires you to provide reasonable accommodations to someone who is a qualified person with a disability. So first step, do they have a disability? And you have to provide it unless there's an undue hardship, which of course means, you know, significant difficulty or expense. And kind of the rule of thumb is that the larger the employer is, the more resources with both finances and employees, the more difficult it is to prove undue hardship. I mean, it's nearly impossible unless it's a key position for Ford Motor Company, but if you're a smaller employer, you at least stand a chance. So often when it comes to COVID issues, you have to look at the direct threat analysis, which is basically, you know, whether the person can perform the essential functions of the job without reasonable accommodation, without creating a significant risk, not just some risk, a significant risk of substantial harm, not just a little harm, to themselves or to others. So, you know, a lot of times this comes up with psychiatric conditions. There are actually people who are you know, paralyzed with fear and anxiety that, you know, psychiatric conditions are becoming more pronounced during this period of time. And of course, there's people with autoimmune deficiencies that make them more susceptible or have some other particular susceptibility. So you have to remember when you're looking at these people, you send out the ADA letter. You should be asking your attorney to write this for you. You can't use the same form letter repeatedly over and over. The EEOC's made it very clear that you can only ask the appropriate questions for that particular circumstance. So you basically have to see what's been provided already medical-wise, what more you're entitled to get. And then, of course, the question is, can they do their job? If it's a work, they have to come into the workplace. Can they come into the workplace without creating significant risk to themselves or others? And so that comes down to how much at risk are they? What would the consequence be if they caught COVID? And of course, there are some people who have disabilities who just can't comply with the COVID-19 policies, like wearing a mask or we want you to work from home. So for example, people who are claustrophobic or who have PTSD or who have breathing problems may have difficulty wearing masks. You may have to look at some other ideas that may assist them, that allow them to come in, like face shields, if they can tolerate that. Where are they going to work? Are they going to fairly be isolated still in the workplace, or are they right on top of other people? So you have to really look at the specific circumstances. And of course, working from home, there are some people that can't work from home, that maybe they've got depression or something. Of course, I don't know if coming into the workplace and being the only person there makes them feel less isolated, but you get the idea. You have to consider these kind of issues when you're looking at ADA. Or if you need them on site, can you require them to come in? So these are the kind of issues that you get into under the ADA. So just some questions. Before any of these are answered, let me just say that the ADA is one of the most complex laws and one of the laws that is most easily violated, even without intending to, by employers. It is a very, very difficult law. And what worked before, what you were advised to do before, doesn't mean that you're going to be advised to do this again, because every circumstance is unique. And if you change just one little fact, then you end up with a different analysis and a different answer to the question. So just always remember that, you know, there's no shame in calling your employment attorney and asking them to assist you with this. So what do you do if an employee tells you he cannot come to work because he has a particular vulnerability? Well, I kind of covered this. You have to run through the direct threat analysis. You know, what will happen if this person does come into work? How great of a significant risk is it? And again, it goes back to the ADA letter. Just one second. And it's just water. And then the next question, what if the employee cannot wear a mask because of a pre-existing medical condition? Again, you have to consider different things that you can do, as I indicated, like a plexiglass face shield or making them more remote from other workers so that there's no risk. And you know, do they work with people who are sick, such that not wearing a mask or coming into the office, coming into the workplace is going to put them at greater exposure? Maybe they work in a long-term care facility, or they work in a hospital, or they're a first responder. So, you know, that's different than, for example, at Plunkett Cooney in the Detroit office, there's usually, you know, 2, maybe 3 or 4 people in there, where normally there would be close to 50. And so people are so spread out, and they basically don't really see each other or work close with each other. And so, you know, to the extent that these people have to be there for specific reasons, they're not bumping up against each other. And they're not coming into each other's workspaces, such that, you know, if somebody couldn't wear a mask, that it would be such a horrible thing if they had, you know, had a face shield that they flipped up if somebody came in, you know, to talk to them. So what if the employee reports that she's having trouble working remotely? That's what I was saying. I mean, I don't know if it's going to be less isolating working in the office when you're the only person there. But some people are really suffering from depression and anxiety, especially in the beginning stages of the pandemic. Anxiety seemed to be off the charts for people. It seems to be settling down more, but these are all very specific issues, and they're real issues too. So you can't just say they're making it up. They do have rights under the law. So what if you need to lay off or terminate an employee who's on a leave of absence under the ADA because of COVID? Well, just make sure it's based on business decisions. Make sure that you can actually explain why it is that you're making this decision, why this person needs to go as opposed to someone else. It's not the fact of the layoff, it's the choices of who is laid off that becomes the issue in these kind of cases. So looking at the mandatory vaccine and incentive programs, I like to use the idea of the carrot and the stick, kind of like what the auto industry does when they are looking at reducing their workforce. First they offer incentives like, you know, if you want to retire early, we're going to pay you X extra money. And so, you know, they have this incentive that they offer, but then they turn around and say, but if we don't get enough people volunteering for a layoff or for retirement, then we may have to just make some cuts and there won't be any incentives. So then the employees think, oh, maybe I should take it while I can. Same thing with the vaccination. You know, if you have the finances that you can offer them a, you know, $50 gift card or $100 gift card or something to go get vaccinated, and they bring in their proof that they've been vaccinated, but let them know that right now you're offering this incentive, you know, good for 3 weeks only. Keep calling and trying to get your vaccination. But if they don't get it, that maybe next month it's going to be mandatory and there won't be any incentive offered. The EEOC has guidance that's come out, what you should know about COVID-19 and the ADA, Rehabilitation Act, and other EEO laws. Well, first they recognize the duty to keep employees safe. So you can't ask them things like, let me take your temperature, or ask the screening symptom, you know, about symptoms before they come on the work site. These are questions and things that you would not normally be able to do, but there is a pandemic. And so they do allow, and the EEOC recognizes that you can do that. And you can require them to get tested too, or you could test them if you've got rapid kits at your disposal, but you can't test them for antibodies. So antibodies are, that test has no basis for an employer to test, because it doesn't mean that the employee is safe and they can come onto the work site like a vaccination would. They don't know the results of having antibodies. And also, those tests aren't highly reliable. So you can't test for that. You can also ask them if people in their household have been exposed to COVID or have COVID, but you can't ask if someone in their family does, because that would violate GINA. And basically you want to know about the household anyhow. So those are the kind of things that you can do that the EEOC allows. It's really exciting reading. If you suffer from insomnia, you may want to read those guidances before you head off to bed. But the key takeaways are, remember that you got to engage in the interactive process, and that you have to accommodate disabilities or religious beliefs. The EEOC says that you can ask for questions and you can seek documentation. But then they say that employers should ordinarily assume the request that it's based on a religious belief, that the employee has a firmly held belief, that the employer should ordinarily just assume that. Don't shoot the messenger, that's what they said. But you have to avoid pre-screening questions. That's for vaccinations, not for entering the workplace. You can only ask medical questions if it's job related and consistent with business necessity. That's the rule always. And these questions that you ask before somebody gets a vaccination, if it's a voluntary vaccination, then they have the right to voluntarily provide that information. But if they decide not to answer your screening questions, there's certain questions that a nurse would ask before you got the vaccination. If they decide they don't want to answer those questions, then you can't ask them or force them. So generally speaking, the EEOC recommends that you have a third party who can conduct the screening and also give the vaccinations if you're going to make them mandatory. Otherwise, you have to get down to, is there some objective basis, some belief that you have an employee who refuses to answer those questions and is therefore denied vaccination would pose a direct threat to the health or safety of others. For example, what's the work setting? Is it a hospital? The goal though is to not require employees to answer those questions, because if you require it and there's no reasonable basis to be asking them, then you shouldn't be. So make it a voluntary program or have a third party do it. As far as, I call it Pmla, as far as Pmla goes, of course, you can still get the tax credit through the end of March if you want to give people the 12 weeks off. In this case, if they're just starting, it would be like 4 weeks off until the end of the quarter. You can still take the tax credit. You're not required to, but keep in mind that it's 12 weeks period in your whatever 12-month period you're using. So if they already took Pmla for some medical condition, they don't get another 12 weeks off during the same year to watch their kid because their school's closed. And so the question is, if they took the time off for the school closing, now they don't have the time off for a medical issue either. Don't discount COVID as never triggering Pmla protections. I mean, people can get seriously ill with Pmla. And so the question is, were they incapacitated for four days or longer? So you have to work through the analysis, not only of the ADA, but of Pmla as well. And so, it's important to get the certification paperwork, follow your standard process. By the way, the Pmla certification on the Department of Labor's website is a new one. It's not mandatory. On a personal level, I'm not a fan. It may be simpler for a doctor to fill out, and they just check boxes and kind of establishes that the employee has a right to take Pmla, but it basically kicks you out of the ability of ever challenging it. Whereas the old Pmla form, if you still have some of those available, you can look at inconsistencies in their answers. You can look at some of the responses that the doctor's given, and sometimes it gives you a basis to deny Pmla or to at least challenge it and get further information. So I'm not a fan of the new one. If you still have access to the old ones, use them if you're my client. And if you don't have access to them, you don't have them, then, it is what it is. They're not available on the website anymore. So the Pmla, remember, this is the state law that applies to employers with 50 or more employees. By the way, the Family First, the emergency expansion of Family Medical Leave Act, it doesn't have that 50 or more guidance, like normally Pmla does. Instead it's got a cap. If you've got, you have to have less than 500 employees in order to have that law apply to you. But normally Pmla, of course, is 50 or more employees. And same thing with the Pmla, the Paid Medical Leave Act. We can't do a really deep dive into this given the time constraints, but we did do a webinar on it. It's probably still on our website if you want to review it. But if you look at the basis for people taking time off under the Pmla, I mean, it's very much geared to what's going on these days. The employee has an illness or is being tested for an illness or needs care for their illness, or a family member has those kind of needs. So, I mean, it's very much in line with what's going on. Keep in mind, this does not apply to exempt employees, but it does apply to employees if they generally work 25 or more hours a week. So a lot of employers don't typically give employees paid time off if they work less than, say, 30 hours. Well, under this law, you got to give them at least 40 hours, but you don't have to segregate the time either. So for example, if you have one bank of time for paid time off, and the employee has already used 40 hours of their paid time off this year, the law only requires you to give them you have to give them 40 hours in your 12-month benefit year that can be used for Pmla. So if they use it for something else, it's like, well, they already used up their time for something else, for fun and games, going to Las Vegas, whatever. So if you look at some of these additional reasons for paid medical leave act time off, next slide, you've got things like the closure of the workplace. I mean, that happened. For the closure of the childcare places, that happened. When the health department tells you that you have to stay home because you've been exposed. So again, the Pmla is really implicated with the pandemic. So keep that in mind, and they can use it in as little as 1 hour increments. So if they need an hour off to go get tested at CVS, then you have to allow them to use just 1 hour time. They don't have to miss a whole day at work. So basically now let's look at the general state of the pandemic facts. And I think the first question will go to Laura. Courtney, hit it.
Yes. So I tried to compile a list of questions that we were routinely receiving. So first and foremost, what exposure from a liability perspective do we have? And Laura, if you can address this. So if I'm running a business and one of my employees comes in and gets COVID at work, what's my exposure as a business owner in that circumstance?
Well, if you employ first responders and it's a first responder who gets COVID at work, there is a presumption under changes to the Michigan Workers' Compensation Law that it is a compensable injury. So that's a comp claim. If other employees get COVID at work, but they're not first responders, there's no presumption, but they may be covered under work comp. If you as an employer have your preparedness and response plan up to date and comprehensive, and you're following all the rules, you are going to generally have protection from employees who get exposure in the workplace. If you're doing the screenings in the morning. Miosha was amended to insulate employers from liability based on employee exposure to COVID-19 in the workplace if the employer is in strict, emphasis, strict compliance with all the statutes, rules, regulations, executive orders, and agency orders that were legally in effect at the time of exposure. So even though the executive orders were determined to be not legal at some point in time, if they were legally in effect at the time of the exposure and the employer was doing everything right and in strict compliance, they should be protected from liability. So I think Claudia, tell me the next one.
Yeah, so then the next questions are sort of go hand in glove, which relate to employees that seem to be manipulating all of the various rules and regulation and a moving goalpost, and then also the people that might just be serial complainers that before COVID complained about everything, and now their complaints relate to COVID and what we're doing wrong or what we're missing. So when you have that situation, Claudia, and you get a call, what are you walking employers through to address these very difficult circumstances?
Hey, if you have insurance and it's a low deductible, I say they're out of there. No, I'm just kidding. Don't do that. You really have to work through the analysis. You can't just, I know they can be, what they call them, PETAs. And you might want to get rid of the employee and it's like, here they are again. But they may actually be exercising rights that they have and they're just really good at it. And so you can't just say, well, it's them again, we're going to ignore it. The last thing you want to do is ever show that you're ticked at them or that you're somehow miffed at their or annoyed that here they come again. Because anything that you say like, didn't you just complain about that last week? Or didn't you just take time off a few months ago for that? Here you are again. That's going to be used against you in a retaliation claim. So you can't show any frustration with the employee, and you have to work through the analysis. Are they entitled to time off under the Family First? Do they have any rights under the state law? What about the ADA? Maybe they really do have a disability. Especially, I know some employers tend to get frustrated when an employee keeps coming back and saying, I'm depressed again. They think they're playing games, but some depression is really debilitating. And so you just have to work through the analysis of each law. Do they get rights under Pmla or Pmla? And just work through it. And if they've got those rights, maybe they exercised rights under one law, a couple months ago, but now they've got rights under another law. Just, give them their rights.
Yeah, and I'm going to take the next two questions. I'll just sort of piggyback onto that. The PETA, which is, I love that acronym. I hate most of them, but that one I do enjoy. Those type of employees are also going to be the most likely to file a lawsuit or a charge of discrimination or a claim. So you just have to keep that in the back of your mind. And I would also make sure that if you have that situation that you're working hand in hand with their supervisor or their managers, because what I've seen recently is that everybody is communicating, at least it seems like it, much more frequently on text messages or on emails or even these like Google chats or Microsoft Teams chats. If you guys are using Teams a lot, I'm sure you've seen people on the Teams chat. And when we're all remote, people are far more inclined to start sending messages and saying things like, oh God, Gary's doing it again. Like, I can't take this guy anymore. And that's all going to be discoverable in a lawsuit. And it's frustration, and we've all been there before, and it's venting, but it's never going to look that way. Okay, through the eyes of a plaintiff's attorney, it's going to be something very, very different. So please, if you do have somebody like that, somebody that either appears to be manipulating or a serial complainer, make sure that HR has a discreet conversation with management so that everybody is handling it the same way. And you don't either have supervisors talking to each other or talking to other employees or sending messages that are going to implicate you down the line. So two questions that I've been handling lately are really relate to a bit of prediction. And this is going to be a very lawyerly answer because we cannot predict the future, and all we can provide you as it relates to future legislation is a best guess. But at this point, the Biden administration has made it very, very clear that they're looking at employee protections and expanding employee protections in a number of ways. So we've seen that immediately with DOL rules being opinion letters being withdrawn, and with the DOL guidance that was issued in early January being put on hold. And I think we're going to continue to see that. It would not shock me at all if the pandemic continues and the cases don't continue on this dropping that we've seen recently, that there will be additional workplace inspections, probably very similar to what we had this year. But I wouldn't be blown away if that occurs. So just something to keep in your back pocket. I would be closely monitoring news outlets. We, of course, will issue rapid reports and blogs when the information comes out. But the Biden administration is going to be very employee friendly, just period. So that's something to keep in mind. Now, what's triggering Miosh investigations? So a big question that we've been getting is, why is Miosh showing up? The only ones that I've seen relate to employee complaints, in particular multiple complaints, or employers just being, for the lack of a better word, stupid. So people putting things on social media, videos. I'm sure that you all heard the story about the Barstool Sports situation where the individual was in Lafayette County, in American County, doing a little taste test when nobody was supposed to be in there. We're supposed to be on a total shutdown, not wearing masks. The people in there aren't wearing masks. And then it's publicized to millions and millions of people. That's going to get Miosha walking in to issue a citation. Same thing if you're just being blatant in terms of having everybody at the office when they don't need to be, multiple employees complaints, no mask enforcement. Once those things start to snowball, you're going to get a Miosh investigation. But as a general matter, they're overwhelmed and they're prioritizing the big issue cases and the big employers. So just keep that in mind. So one last question before we break off into our breakout rooms. And this one's really for you, Claudia, and anybody else can chime in. But I've been getting this, which is how often do we need to update our COVID policies? Is this a monthly thing? Do we need to redo them now that we're in 2021? What are you doing with your clients in terms of updating their COVID policies?
Well, generally only when there's substantive changes. I mean, the Families First, they had a poster that you could post and publicize that kind of spelled out employees' rights. So some of my clients use that as notifying employees and as the update to their handbook, and others did a more thorough revision to their policies. But these things are all very temporary and, may come back again, given that the Democrats now own the White House and both chambers of Congress. So things could change. So if there are substantive changes, you definitely should be making updates. As Courtney said, watch the news, visit the CDC website on a frequent basis, because the rules for quarantines are changing all the time. So pay attention to that. And of course, sign up for our blogs that we post. And of course, newsletters that our firm puts out. But there's a lot of good sources. Detroit Sherm puts out a lot of newsletters and updates. You got to be savvy, paying attention to what's going on in the news, and just make sure that you are following it. And if you're unsure whether or not a change affects you, then contact your employment attorney and we'll be glad to assist you with anything you need.
Great, thank you. So at this point, unless somebody has a question, we will go into our breakout rooms. So you should have all been provided the option to choose a breakout room, whether it's free speech, which will be, I'm sure, a really good discussion with Mike Bogren and Christina Coral, or it's wage and hour, piggybacking on some of the remote work issues that we mentioned today with myself and Laura Dinan. You're going to get an update as it relates to breakout rooms. If you had a question that you didn't get answered or that you didn't have the opportunity to ask, hold it or send it in the chat. You can put it in the chat right now, and then we'll address it when we go back. Same thing, if something comes up in the breakout room, we will have plenty of time to address it when we come back if need be. All right, so with that, we will all bounce off into our breakout rooms. All right, so I hope everybody's had an opportunity to jump back on. While everybody's getting comfortable again, I wanted to ask Christina, for the people that were talking about wage and hour issues and sort of what to expect moving forward with Laura and I, what did they miss in your breakout session?
Well, we had a lot of very good information presented about what employers, both public and private employers, rights and responsibilities and restrictions are with respect to their employees or prospective employees' conduct on social media and on the internet. And so I think we all sort of came to the conclusion in our session that there are so many different and conflicting findings by courts out there when it comes to posts by employees on social media, that it is really important that if you do have an issue where, for instance, you get a complaint from an employee about another employee's posts on social media, that you are consulting your legal counsel on these issues, because there are just no bright line rules anymore when it comes to what's permissible and what's not permissible and what you can take action with respect to on social media. So that was really our takeaway from our session today.
That's a good takeaway, and ours is somewhat similar in the sense that with wage and hour issues, a lot of which really rely on DOL guidance and administration interpretation, we are in a bit of a holding pattern because we have a freeze on DOL rules that were issued in early January. We have several opinion letters being withdrawn at a rapid pace under the Biden administration, and more to come, I'm sure. So for employers that are trying to wade through quite muddy waters when assessing some of these FLSA and wage and hour issues, we caution you not to rely on any guidance that was issued under the Trump administration, or at least if you are relying on that guidance, to do so while acknowledging that there's a pretty good risk that it's going to be withdrawn or it will just not be relied upon under the current administration. We also encourage everybody to contact us if they have any questions or concerns, because this is a moving target. Go to the DOL website, which is a pretty good user-friendly website to get information. They have contact information as well to call you with questions. They do respond to opinion letters, so we're gonna have to wait and see. But for now, we have independent contractor rules that are frozen. We have opinion letters being withdrawn. So it's important to just make sure that you're very, very confident about certain things. And I got up on a bit of a soapbox, but one of the things that I'm seeing over and over and over again is just hammering independent contractors and joint employers. Just really, really trying to find that people are employees and not independent contractors, or that people are, working for two entities together to accumulate those hours for wage and hour purposes. Because if you're not an employee, you don't have all those protections of the various laws we talked about today. And the intent is for those to be applied very broadly. So I just caution everybody to keep the eye out on those issues moving forward, stay abreast of our regulatory guidance, and we'll try to keep you updated the best we can with all these moving targets as well. Any questions? Anybody want to chime in? If there's anybody on video that raises your hand. Oh, I got Claudia.
Hi.
Somebody cut off her mic.
I was just going to say what's going to be really interesting for a legal nerd like me is, while we have the Democrats controlling both chambers of the House and the White House, we now have, at least theoretically, a conservative Supreme Court. So we could end up with all kinds of really liberal rulings that eventually are chiseled away at by our conservative Supreme Court. One of the things I'm looking forward to is someday over the rainbow, there will be a place where the ADA goes up to the Supreme Court and our conservative bench says it was never intended to be a leave of absence law. It was designed to help employees stay in the workplace and do their job. So watch for some, interesting cases working their way up, and we're going to be going back and forth. And of course, the takeaway from all this is that attorneys will really be the heroes, because what the legislator grants, the hero attorneys will take it away as we chisel away at the rights. So just something to think about. And the free speech thing too. He came in and he talked about free speech, but if it's not a union or a municipality, a government entity, there's a whole lot more that employers can regulate. And I just want to make sure that clients understand that the restrictions and when you have to be careful is more applicable in a union setting or a government setting than private employment. So, private employment, you can just kind of, instead of giving them a mask to wear, put a muzzle on them.
And I have a question about a COVID-related thing that came up in our chat from one of the earlier sessions about whether, the question is whether employers can ask an employee if they've received the vaccine. So
Yep.
this has come up, and yeah, I mean, the easy answer is yes, right? So a lot of times this comes up in terms of incentivization programs where, you know, if you get the vaccine, we'll give you an extra PTO day or something along those lines. So you can track that. What you don't want to do is to be getting the unrelated medical information or to be asking pre-screening or unnecessary medical questions about that process. You also don't want to push back if somebody objects to getting a vaccination or says they're not going to participate in the program because of religious exemptions, as Claudia covered. But in that same vein, there was one thing that I wanted to touch on in my breakout, and time got away, but these wellness programs. So if you are a company that's considering incentivizing vaccines, I do want to make sure that you're aware that it's a bit of a gray area in terms of how big the incentive is as to whether that could be considered compensation. So for example, if you decide to do bonuses, so employees that get a vaccine will get like a $100 bonus, that arguably is related to a wellness program, and the EEOC has said that those type of benefits under a wellness program don't count as regular compensation, meaning you don't have to factor it in when figuring out what the overtime rate is. But the bigger that number gets, the bigger the incentive is, the less likely it is that it would not be deemed compensation. So if you're looking at vaccination programs, just keep in mind when you're talking about incentives, it's not just a matter of can we do it, it's a matter of if we do it, what collateral damage might we have on the back end in terms of paying our employees and making sure that we haven't missed a potential wage and hour or employment issue along the way. Let me just make sure that we have no more questions. I believe, oh, one last question. This is the last one. We're running up against our time here, but with regard to COVID return to work documentation, in the past, employers were discouraged from asking for doctor's notes as it put too much burden on already stressed healthcare practitioners. Is that no longer the case? So the COVID back to work rules are found in Michigan law right now, that PA 339 of 2020, at least for us. Christina's in Ohio, so she doesn't have that lovely piece of legislation to deal with. But for us here in Michigan, and so the only time when a doctor's note would come into play is if the employee is being returned pursuant to a healthcare provider's orders or recommendation. And so they should just have a doctor's note saying that. So if they want to come back because they said, listen, my doctor told me I don't have to quarantine this entire period, then they'd be providing that note. It's different than saying, we have to get a note from you to bring you back. You should not be saying, we refuse to put you back in the workplace unless you have a doctor's note, if they've met all the other quarantine and applicable requirements at this time.
Unless they were off on Pmla.
That's true. So yeah, Pmla is a different thing, right? If it's a full-blown FMLA issue, then you're entitled to all the certification paperwork, but that's consistent with that. That's not necessarily the COVID issue under Michigan law or our Miosha rules. Thank you, everyone. We sincerely appreciate it, and good luck. Good luck.
Bye.
Bye. Thank you very much.